the information was to be used for. Your Excellency, according to the European Court on Human Rights, in the case of Sunday Times versus UK and Marlon versus United Kingdom, any law that interferes with any rights must be clear and must not grant unfettered discretion on any member of the executive. It is clear from this paragraph, Your Excellency, that the presidential directive is unclear, and it also grants unfettered discretion on the NSA because it allowed the NSA to deploy capture it without any instruction on what step to take. The NSA acted within its own whims and caprices. As such, Your Excellencies, we argue that there is no legal basis in the present case, and a further analysis of the necessity and proportionality requirements is not necessary, as failure to satisfy one requirement is sufficient to find a violation. Your Excellencies, if there are no questions, this concludes our submission on the first claim. Agents will now move on to address the second claim. Your Excellency, the second claim concerns two independent issues. The first is whether FGN has violated the NDPA.
Sorry, just 1 minute.
Yes, Your Excellency.
So is it the case that you've abandoned your argument with respect to necessity and proportionality? Because I would like to hear your argument on those two other points.
Yes, Your Excellency. You have a concern, Your Excellency? Oh, okay. Could I see how many minutes I have left? Thank you.
Yes.
Most kind of Your Excellency. The first claim in the second, under the second claim, Your Excellency, is that FGN violated the NDPA. Section 24 of 1 of the NDPA states that any processing must be lawful, fair, and transparent. Particularly with respect to the fairness requirement, the principle has been recognized to preclude algorithmic outcome or algorithmic biases. Your Excellency, in the present case, Capture It, the artificial intelligence, exhibited algorithmic biases and has discriminatory outcome against people from Kembari, as seen in paragraph 12 and paragraph 13 of the complaint. This is a violation of section 24 of 1 of the NDPA. We rely on the case decided by the National Finnish Non-Discrimination Tribunal, known as the C-216/2017 case, where the Finnish Non-Discrimination Tribunal held that there was a violation of the due process because the plaintiff in that case was denied access to credit facility because of his place of residence and because of his native language. In the present case, it is even worse. Mr. John Cole has been profiled as a potential terrorist. A potential terrorist, a criminal, Your Excellency, because he is an activist and he's from Kembari. This is discriminatory and it is an algorithmic bias, a violation of section 24 of 1 of the NDPA. On the second issue under the second claim, Your Excellency, with respect to copyright, we submit that there was indeed an infringement of Mr. John Cole's copyright. For copyright infringement to be found, Your Excellencies, we note that his personal data must first constitute one of the copyrightable works under Section 2 of the Copyright Act. The answer is yes. Your Excellency, we rely on the authority of the case of the University of London Press versus University Tutorial Press, where Peterson J. stated that any work that is written, whether printed, amounts to literary work. If I may refer this honorable court to paragraph 9 of the complaint. This court would find that Mr. John Cole's personal data that were collected include his telephone addresses, phone numbers, as well as social preferences and hobbies. We argue that this information were contained on legit social platform, and as such, they constitute digitally written work, Your Excellencies, and satisfy the literary work test. Two other conditions must be met, the originality and fixation test. We submit that these requirements are also met, particularly with respect to originality. The requirement is that some efforts must have been expended. We argue that some of the personal data upon which legit social lend Mr. John Cole's possibility to commit crime, Your Excellency, was based on some of his publications, some of his content on legit social. We submit that the effort he expended in typing out those information satisfy the originality requirement, which says some effort. Your Excellencies, this concludes our submissions on the merits. With your kind permission, Your Excellency, agent concludes and submits himself for further questions from his honorable court.
Okay, well done. I don't know if this feedback should be given to you now or after, so it doesn't give others an undue advantage, right? So let's do that after, but well done, you dismissed that.
Thank you, Your Excellency. Your Excellency, I noted you had a question before.
No, I mean, you can address it. Since you are
Okay. Your question, Your Excellency, was as regards our argument on necessity. Your Excellency, with respect to necessity and proportionality, the CJEU had cases considering both circumstances and has combined those two requirements to mean that any interference with a fundamental right, such as the right to privacy, must be such that there must be a present social need, Your Excellency, a present social need. But in the present case, Your Excellency, there is no present social need that necessitates a deployment of capture rate. And also, there is nowhere in the fact, although the first respondent may argue that they acted on the basis of national security, but there is nothing in the fact that threatens national security, Your Excellency. At best, the only fact they could possibly try to rely on is on paragraph 12 of the compromise, which says that people developed a certain level of political activism online. Your Excellency, this is consistent with their right to freedom of expression, as recognized by the General Comment number 34 on Article 19 of the ICC. Your Excellencies, that particular comment says your right to freedom of expression covers political discussions and criticisms of government. Therefore, their action is only a lawful exercise of their rights to freedom of expression. And the action of the respondent in this case is not justifiable on the basis of necessity and proportionality. But that is just an alternative argument, Your Excellency, as they have failed to satisfy the legality requirements. Your Excellency, if that satisfactorily answer your question. Thank you, Your Excellency. Your Excellency, you have a concern? Your Excellency, seeing that I have concluded my argument, agents respectfully invite his co-agent to address this honorable court on the remaining claims in merit.
Right.
Thank you, Your Excellency.
Yeah, just so that the others don't, yes, maybe you're excused. You don't need our validation, right? And so just do your thing, okay?
Madam President, Your Excellencies, may it please this honorable court. Announcing appearance before the bench is Tiwalade Adekile, and as earlier introduced, I am co-agent for the applicants in the matter before this court. In the next 14 minutes, I will address claims C, D, E, and F in merit on the illegality and wrongfulness of the actions of the respondents, the applicants. With your permission, I will now proceed to make my submissions. Most obliged, Your Excellencies. In the first of my submissions on claim C, that the federal government of Nigeria did not comply with the provisions of the Nigeria Data Protection Act 2023 when it transferred the personal data of Mr. Jones Cole and others to recipient country, the Gambia. The agents for the applicants find that in order to firmly establish this claim, we bring the attention of the court to section 41, 42, and 43 of the NDP that provide conditions for lawful cross-border transfer of personal data. Your Excellency, section 41 provides that a recipient country of personal data must be ensured to afford adequate levels of protection for personal data that it intends to receive. Section 42 goes on to list what consists adequate levels of protection, giving features. In section 43 of the same act, we see certain conditions listed, among which are the unwithdrawn consent of the data subject, the necessity for the performance of a contract which the data subject is a party to, amongst many other conditions. But when we turn our attention to paragraph 11 of the facts, where the respondent in this case makes one of many errors against the applicants, we see that they transfer personal data of Mr. Jones Cole to the recipient country, the Gambia, and according to paragraph 11, without any clear legal justification. Furthermore, they do this, as we see in the final lines of paragraph 11, without his approval or consent, already going against the provisions of the NDPA. First, we'd like to bring to the attention of the court that the Gambia has not been recognized as having adequate levels of protection according to section 42 of the NDPA. That states that adequate levels of protection would include having an existing data authority as equivalent to the NDPC in Nigeria, being subject to a data protection law that ensures the enforceability of rights of data subjects, amongst many others, Your Excellencies. Furthermore, section 43 provides, specifically with respect to paragraph 11 of the facts, that the unwithdrawn consent of the data subject is required to make cross-border transfer necessary. It's also required that the data subject is informed of the risks of such transfer where his personal data is concerned. Based on this, Your Excellency, we argue that the federal government of Nigeria did not comply with the provisions of the NDPA. The respondents may argue that the federal government should pseudonymize the personal data of Mr. Jones' school in paragraph 11, but we argue that pseudonymization is only a security measure provided by section 39 of the NDPA after the conditions of sections 41, 42, and 43 have been met. Furthermore, Your Excellencies, pseudonymization based on research by renowned anonymization experts and data activists from the University of Texas, University of Melbourne, and many more, has shown to not provide complete protection to the identity of data subjects where data security is concerned. Your Excellency, this concludes our arguments on claim C, that the FGN did not comply with the provisions of the NDPA. On claim D, we submit that Light Touch Incorporation, the third respondent in this case, is a data controller. And in being data controllers, they failed in their obligations to the applicants when they allowed the federal government of Nigeria to mine their platform for their personal data. Your Excellencies, we bring your attention to section 65 of the NDP, the definition section, which defines a data controller as any body, any individual, any public commission or agency that by itself or jointly with others determines the means and purposes of processing personal data. Furthermore, we bring your attention to section 2 of the NDPA that increases the scope of a data controller beyond those who are domiciled in Nigeria. When we look at paragraph 6 of the facts, we see that Light Touch Incorporation is a company of American descent, and we see also that it has no physical presence in Nigeria. We argue, Your Excellencies, that this does not limit their communications. We argue that Light Touch Incorporation failed in this obligation. They were able to do this, and based on the data that they got and processed, able to discriminately arrest Mr. Jones Cole for a crime of terrorism, an unfounded allegation against Mr. Jones Cole, and a stain on his reputation. Furthermore, Your Excellency, we argue that when Light Touch Incorporation in paragraph 19 of the fact claimed that it owed no legal obligation to the applicant, it erred grievously. As clearly outlined by section 24 of the NDP, it does owe a duty of care, and it is a data controller. Your Excellencies, on claim E, that Light Touch Incorporation erred when it refused transfer of personal data of Mr. Jones Cole to another platform. Section 38 of the NDPA and Section 34 provide for the right to data portability and the right for data subject to request erasure of his personal data in the hands of a data controller. These rights have been recognized as extensions of Section 37 of the Constitution, which provide for the right to privacy and family life. Your Excellencies, when in paragraph 14, Light Touch Incorporation decided, after Mr. Jones Cole had suffered discriminatory arrest and allegations of terrorism, to move his personal data to another platform for the security of his own life, refused his personal data transfer request. They contradicted the NDPA, the Constitution, and infringed upon his right to data portability directly. Based on this, Your Excellency, we submit that they were in error when they refused the service of transfer of personal data. Your Excellency, furthermore, we present the case of Google and Spain that clearly outlined the right to be forgotten as an interpretation of the right to data erasure. Data subjects have the right to request that their data no longer be in the custody of a data subject, especially when data subject, the data controller, has no lawful basis for retaining said data. Your Excellencies, on claim F, our final claim, that the Nigeria Data Protection Commission is not independent as required under relevant law. Your Excellencies, Article 16 and Article 17 of the Supplementary Act on Data Protection within ECOWAS provide that a data authority within a member state must be incompatible with membership of government and must be immune in respect of its opinions when performing its functions. It must not be subject to the instruction of any other member of the executive. I return to paragraph 15 of the facts in this case. Mr. Jones Cole had suffered non-consensual cross-border transfer of his data. He had suffered arrest, and he had been denied measures to take in order to prevent further arrest and discrimination by Light Touch Incorporation. He finally approached the NDPC to seek redress and stated a complaint. The NDPC gave a very brief response. Upon their response, they went ahead to consult with one of the subjects of Mr. Jones Cole's complaint, the NSA, and then decided that his matter was lacking merit and deserved a dismissal. Your Excellencies, Section 7 of the NDPA states that the NDPC must be independent in the performance of their functions, and the CJEU has held, in the case of EU Commission versus Hungary, that influence whatsoever, whether direct or indirect, can affect the independence of a data authority where taking decisions with respect to citizens are concerned. Hence, it is not necessary, as the respondents may argue, that it is not important, Your Excellencies, as the respondents may argue, that the NSA's consultations or advice may or may not be binding on the NDPC, but that influence has been effected on them to take their decision. Your Excellencies, it is based on this that we argue that the NDPC clearly saying the facts in paragraph 15, with respect to relevant law being the NDPA, is not independent as required as of a data authority. Your Excellencies, this court has been tasked with the heavy burden of determining the illegality and wrongfulness of the actions of the respondents, as well as pronouncing whether the human rights paraded by member states of this community have any true meaning in the reality of their existence. We urge this court to maintain its standard of justice and find in favor of the applicants. And we hereby, Your Excellencies, adopt our memorial as provided on page 30, adopt our prayers as provided on page 34 of our memorial, that this court find that it has jurisdiction, the claims are admissible, the applicants have locus standi, and that the issues in merit are found in favor of the applicants. Most obliged, Your Excellencies. If there are no questions, agents will humbly seek leave of this court. Most obliged, Your Excellencies.
I have a question.
Yes, Your Excellency.
So you're saying that the NDPC is not independent. That's the crux of your argument, right?
Yes, sir, in the final claim, sir.
Okay. So, but you have not really adduced key indices as to why they are not independent.
Okay, sir. Your
Can you shed
Excellency.
a bit more light?
Yes, Your Excellencies. Your Excellencies, the NDPC, Mr. Jones Cole approached the NDPC in paragraph 15 after he had discovered that his rights under the NDP were not being addressed by Light-Chain Corporation. And after he had also discovered that he was subject to automated processing.
I'm conversant with the facts, and I think we're conversant with the facts. You have said that the NDPC is not independent as required by law and pursuant to the provisions, I think section 7 of the enabling law that establishes that, right? I'm saying to you, on what basis are you arriving at that conclusion?
Yes, Your Excellency. On the basis that in paragraph 15, the NDPC had to first consult and seek the advice. Your Excellency, my time is up. I request 30 seconds to answer your question.
Go ahead.
On the basis that upon receiving his complaints, the NDPC first had to consult and seek the advice of the NSC, a subject of that complaint, before deciding to dismiss his matter and deciding whether or not to investigate his matter.
Is that what defines independence?
Your Excellencies, in the case of EU Commission on Hungary, the CJU has held that influence, whether direct or indirect, can affect the independence of a data authority within a state, and whether or not the influence is binding or not.
So what are the exceptions to that?
To the rule on independence, Your Excellency.
So when you say your argument is that the NDPC should act without consultation and should take a decision, right? That's your argument, that the NDPC should be able to be the final arbiter, take a decision, take action without consulting anybody or taking directives, using your words, directives, right? I'm not disputing that. What I want you to throw light on is, are you saying that because they consulted with the office of the NSA, that undermines their independence?
Yes, Your Excellency, they sought the advice before being able to take a decision on a matter that affected, the NSA was a subject of, Your Excellency. It does undermine their independence.
So did you put into clear context the role of the office of the NSA and the implication of the facts that gave rise to that directive?
Your Excellencies, the role of the Office of the NSA as a National Security Advisor should not affect Mr. Jones Cole's complaint with reference to Light-Chain Corporation not enforcing his right to data portability or his right to erasure of data, should not also affect the rights not to be subject to automated processing as provided by the NDPA. Your Excellencies, in the CEJU case earlier mentioned, it stated that even indirect, in that case, the data authority in Hungary a European Union country had been said to be influenced by another member of government, a minister or commissioner, I believe. Agents cannot give proper details at this time, but in that case, the court did hold that even indirect influence can undermine.
That's what constitutes indirect. So you're basically saying that consultation constitutes influence.
Your Excellencies, with respect to what exactly Mr. Jones-School complained about, the agents for the applicants can understand with respect to the collation of data, for instance, but with respect to Light Touch Incorporation, not refusing to transfer his data to another data controller or refusing to erase his data, there should have been there should have been at least investigation to that regard of his argument before dismissing, as stated in the facts, each component. Your Excellency,
This could not have been part of the investigation, the consultation with the NSA.
well, it would have been more believable, Your Excellency, if they had consulted also with Light Touch Incorporation and consulted also with the other subjects of who are non-members of government of the complaint by Mr. Jones-School. But as seen in Article 16, they were compatible with other members of government before arriving at their decision.
Tiwalade,
Yes, Your
your
Excellency.
arguments, see, we're not faulting your arguments on independence. We're faulting your formula
Yes.
and how you have arrived at that conclusion, right? Now, when you hear NSA, automatically you talk about national security.
Yes, Your Excellency.
National security has repeatedly been found to be something that is an exception, right? And so certain blanket provisions are sidestepped for issues of national security. You did not create a nexus in your argument to say to us, the facts that have led to this directive did not meet the threshold for it to be referred to as a security issue or as something that undermines national security, right? Two, your argument on the independence or otherwise of NDPA does not hit the nail as to why they are independent or not, right? You cannot determine independence on the basis of consultation with agencies. Remember, the NDPA remains an agency of government, right? Its independence in the performance of its role is within limits. So you have not also said to us, I would have expected when dealing with issue of independence, you talk about funding, you talk about oversight, you talk about constitution of management, appointments, right? And then you talk about control. If there's an agency that provides superior oversight, right? These are the factors that determine. So when they talk about, for instance, the independence of the judiciary, it is established from the place of being the third arm of government, where its funding comes from a fund called the Consolidated Fund that is not determinant on executive action or legislative action. So as everybody is dipping their hand in the pie, they are also dipping their hand in the pie to get their funding. Is that the same for NDPA? Is who pays the piper dictating the tune in this context? I say this because as lawyers, you must understand that in making, in drawing conclusions that do not necessarily have a legal basis, you must do your homework well. If not, you will be making wild allegations just to drive home your case. Do you understand me?
Yes, sir.
You get the point?
Yes. May I? Okay.
And perhaps just to build on what he said. So in the context of independence, I think what we expected you to have demonstrated is the different types of independence that we have. So we have operational independence and we have financial independence. Now, given that this directive is coming from the NSA, maybe we don't necessarily need too much details as to financial independence, but is directly linked to operational independence. So the consultation, it didn't demonstrate to us that he acted on that consultation. That is very key, because they can consult, and at the end of the day, it's just advisory. You're not mandated to take their opinion. And we're not sure, there's no direct link, or you've not demonstrated with evidence that they acted on the consultation that they received. Because how else can you do investigation? You can do investigation from, I mean, you have the sole discretion as the NDPC to do investigation based on the terms of your acts. So if they decide that in adjudicating this case or in coming to a findings, meeting with NSA will take me close to the findings that I need, then it's up to them, except you're able to demonstrate that in acting on that directive or the findings that they got, that they undermined their independence under their acts. And I think in demonstrating that, we needed you to go back to the Data Protection Act and specifically speak to provisions that deal with the independence of the Data Protection Commission, right? And you then build from there. That is the expectation.
Yes.
But you don't appear to be a lawyer that doesn't need to wire.
Properly guided, Your Excellencies.
I also make your own wire allegation. Yes,
Thank you.
don't take advantage of this advice. If there are no wire allegations in your paper, you know that
Thank you very much, Your Excellencies. Your Excellencies, and may the court be pleased. Once again, I am Barakat Ebunlua Ogungbe. Your Excellencies, I'll be addressing this honorable court on the preliminary issues as well as substantive issues 4, 5, and 6 within 15 minutes. And my co-agents will be addressing this honorable court on issues 1, 2, and 3 within 15 minutes. May I proceed, Your Excellencies? Thank you very much, Your Excellencies. Your Excellencies, on jurisdiction, it is our contention that this honorable court lacks personal jurisdiction over the second, third, and fourth respondent. Your Excellencies, jurisdiction is very, very important. In the case of Chude Umba versus the Republic of Ghana, this honorable court held that jurisdiction is the blood that flows through the veins of the court, and any adjudication on a case without jurisdiction is building something on nothing and expecting it to stand. Your Excellencies, personal jurisdiction refers to the power of the court to decide or to adjudicate and make decisions in regards to a party that has been sued. Your Excellencies, in the case of Aruna Wakani versus ECOWAS Commission and others, this honorable court held that it has jurisdiction over members of the Economic Community of West African States. This is also the position in the case of Peter David versus Ralph Uechi. Your Excellencies, the second respondent, the Nigeria Data Protection Commission, the third respondent, Light Touch Corporation, the fourth respondent, Light Gold Consultancy Africa, are not member states of the Economic Community of West African States. Your Excellencies, based on this, it's a submission that this honorable court lacks personal jurisdiction over the second, third, and fourth respondent. On admissibility, Your Excellencies, it is our contention that this case is inadmissible before this honorable court. Your Excellencies, jurisdiction is the firm foundation on which the court adjudicates on cases. Without that firm foundation, every other action conducted in relation to that case is going to be a future effort. Your Excellencies, premised on this, and having established that this honorable court does not have jurisdiction, it's our contention and submission that this case is inadmissible before this court. Your Excellencies, on local standing, we do not contend the standing of the first applicant and second applicant in this instant case. Your Excellencies, pursuant to provision of Section 9, subsection 1, and Section 10, subparagraph D of the supplementary protocol on data protection within ECOWAS, the first applicant, the second applicant, they have the standing before this court. And also in the case of SERAP versus Nigeria and UBE. Your Excellencies, on local standing, it's a submission that the first and second applicant have the requisite local standing before this honorable court. If I may, and if it pleases the court, my co-agent will be addressing this honorable court on substantive issues 1, 2, and 3. Thank you very much, Your Excellencies. Yes. Yes. Yes.
Your Excellencies, and may this honorable court be pleased. I remain Olagunju Aishat, and I shall be addressing this honorable court within 15 minutes on our substantive issues 1, 2, and 3. If it pleases this court, I would like to proceed. On the first issue, Your Excellencies, pardon me, Your Excellency. May I proceed? Thank you. On the first issue, Your Excellency, we contend before this honorable court that the first respondent, that is the FGN, had proper legal basis for the collection and aggregation of Mr. Cole's and several other people's personal data. Your Excellency, in the case of Incorporated Trustees of Digital Rights Lawyers versus LT Solutions, the court stated that the right to data privacy is hinged, or in other words, premised on the right to privacy as guaranteed under Section 37 of the Nigerian Constitution. Your Excellencies, what this suggests is that as Section 45 of the Constitution provides that certain rights are to be considered derogable. Your Excellencies, you might ask, what do I mean derogable? Derogable rights refers to such fundamental human rights that may, in certain circumstances, be considered limited. Circumstances which may include public morality, public health, or, as it is relevant in this instance case, national security. Your Excellencies, I rely on Article 13 of the African Union Convention on Cybersecurity and Personal Data Protection to state before this honorable court that the right to data privacy may be limited, and also relying on Article 65 of the Supplementary Act on Personal Data Protection within ECOWAS, which states that the right to data privacy may be limited where it is done in an health emergency, where it is done for public interest or national security, as it appears to be the case in this instant case. Your Excellencies, in referring this court to paragraph 12, particularly lines 2 to 6 of the fact agreed upon before this honorable court, where it was stated that the social media platform, Legit Socials, ceased to be used for the purpose for which it was initially created, that is, for social interaction, but had been converted into a platform to be employed in inciting the people against the government of the day. Your Excellencies, as if this was not enough, it was also used to spread fake news and proliferate hate speech. Your Excellencies, I do not need to continue to reascertain before this court that this obviously serves as a complete and proper justification for the processing done by the government in this instance case. Your Excellencies, I refer this court to the case of United Kingdom versus Kang, where the requirement for legality, necessity, and proportionality was stated. Your Excellencies, still standing on paragraph 12, specifically lines 2 to 6 of the facts before this honorable court, where it was clearly stated that the social media platform in question, that is Legit Socials, was now used as a space for inciting the people against the government of the day. Your Excellencies, I can only imagine, or we all can only imagine, the numerous dangerous outcomes that the continued perpetration of these could have led to. Your Excellencies, I assert before this court that this satisfies these three requirements satisfactorily. On this note, Your Excellencies, I submit before this honorable court that the federal government of Nigeria, that is the first respondent in this case, had proper legal basis for collection and aggregation of Mr. Cole's and several other people's data from Legit Socials. If I may proceed, Your Excellencies, our argument on the second. Yes, Your Excellency. Yes, Your Excellency. Like I just stated, the right to privacy as held in the case of Incorporated Trustees of Digital Rights Lawyers Initiative versus LT Solutions. In that case, Your Excellencies, the court stated categorically that the right to data privacy is hinged on the right to privacy. And I also referred this court to Section 37 of the Nigerian Constitution, which guarantees this right, as well as Section 45 of the Nigerian Constitution, which states that including the right to privacy under Section 37, certain rights are considered derogable or limited in certain circumstances. And I gave some of such circumstances. Yes, Your Excellency. Yes, Your Excellency. I stated Section 37 of the Nigerian Constitution, Section 45 of the Nigerian Constitution, Article 65 of the Supplementary Act on Personal Data Protection within ECOWAS. Obviously, before this honorable court, the most important will be Article 65 of the Supplementary Act on Personal Data Protection within ECOWAS. May I proceed, Your Excellency? On issue 2, Your Excellency. You have a question, Your Excellency? Thank you very much. On issue 2, Your Excellency, we contend before this honorable court that the federal government of Nigeria did not in any way or manner violate the NDPA and by extension did not in any way infringe on Mr. Cole's copyright. Your Excellencies, for ease of presentation, we have stratified our arguments on this issue into 2 major standpoints. On the first standpoint, Your Excellencies, we contend before this honorable court that the federal government of Nigeria, that is the first respondent before this honorable court, did not in any way violate the NDPA. Your Excellencies, Section 2 of the NDPA provides categorically that the act in its application shall extend to data processors and controllers, whether domiciled in or out of Nigeria, provided that they process the personal data of Nigerian data subjects. However, Your Excellencies, in addition to this, Section 3 sub 2 of the Act provides that the Act shall not apply, Your Excellencies, to any data processing done by a competent authority. In offering a definition of competent authority, Your Excellencies, Section 65 of the Act provides that a competent authority refers to the government of Nigeria or any other foreign government. Your Excellencies, what this suggests is that the processing done in this instant case is not governed by the NDPA. Your Excellencies, we are of course not oblivious to the fact that this Section 3 sub 2, which excludes Nigerian government, also has its own further exceptions under Section 24, 25, 36, and 40 of the Act, Your Excellencies. We, however, argue before this honorable court that these same sections also recognize public interest as an exception under which the processing done by the government will still be permissible. And as established before the honorable court, the processing done by the government in this instance case was necessitated by a matter of national security or public interest. It is on this note, Your Excellencies, that we submit on this standpoint that nothing in the 20 paragraphs of facts before this court suggests that the first respondent has in any way violated the NDPA. Your Excellencies, I move on to the second standpoint. On this standpoint, Your Excellencies, we contend before this honorable court simply that the FGN did not in any way infringe on Mr. Cole's copyright. Before I proceed, Your Excellencies, I must ask the question. I must also refer this court to the well-known maxim, nemo dat quod non habet. That is, you cannot even give what you never had in the first place. This poses the question, was there even a copyright to be infringed upon in the first place? I answer this question to be no, Your Excellencies. Your Excellency, the Copyright Act, that is the most updated version, Your Excellencies, 2023 Copyright Act, in Section 2 sub 1, categorizes certain works to be eligible for copyright. And this may include, among others, literary works, musical works, audiovisual works, among others. Your Excellencies, by extension, Section 2, Sub 2 of this same Act provides that the works referred to as eligible in subsection 1 shall only be guaranteed copyright protection under the Nigerian law after fulfilling certain conditions. I move on to list. On the first condition, which states that the owner of such work must be able to establish satisfactorily that adequate or enough effort has been expended to ensure the originality of the said work. The second condition, Your Excellencies, is that such idea as copyright in Nigeria protects the expression of the idea and not the idea itself, that such idea has been fixed in a manner of expression, Your Excellencies. I must also state that Section 3, Sub 2 of this Act, Your Excellencies, states that certain works are to be considered ineligible for copyright. That includes our coat of arms, for example, but particularly for this case, mere data, Your Excellencies. I must state before this honorable court that the matter in contention revolves around data, Your Excellencies, Your Excellency. Article 1 of the African Union Convention on Cybersecurity and Personal Data Protection posits that personal data is to be defined as any information regarding an identified or identifiable individual by which such person may be identified by making reference to certain factors. On this note, Your Excellencies, I proceed before this court that the matter in contention, that is the subject of this honorable court, does not even qualify for copyright protection in the first place. So why must we come to argue whether something that never existed has been infringed upon? Alternatively, Your Excellencies, assuming but not conceding that there was even a copyright to be infringed upon, we argue before this honorable court that the right to own intellectual property is also associated with the right to own property as guaranteed under Section 44 of Nigerian Constitution, and by extension is derogable or may be limited by Section 45 of the Constitution in matters of public or national security. I submit on this issue that the FGN did not in any way violate Mr. Cole's copyright and also did not violate the NDPA. If there are no questions, I will proceed to the third issue.
You keep referring to the Nigerian Constitution and Copyright Act. What is the status of those instruments before this court?
Yes, Your Excellencies. Your Excellencies, if we make reference to Article 9 of the Supplementary Act Supplementary Act on the Community Court of Justice within ECOWAS, it states that this court has the authority to interpret its own conventions as well as other international principles and conventions. However, we understand that this court does not intervene into the interpretation of local laws. We are, however, stating these laws before this honorable court to ascertain before this court that this is what the local law posits. This is what is obtainable within the Nigerian borders, Your Excellencies.
Does that relate to the international obligations, in this case, the regional obligations?
Can I please get a clarification?
How does that then relate to the international obligations in question?
Of course, Your Excellency. We are not disputing that Nigeria, as a signatory to the ECOWAS Act and other internal protocols, has certain obligations under these international instruments. However, Your Excellencies, what I am simply arguing before this court today is that under the Nigerian law, there could not possibly be a rational situation within which there could be a copyright protection guaranteed for the subject matter in this instance case. May I proceed, Your Excellency? Yes, Your Excellency. On the third issue, Your Excellency, we contend before this honorable court that the FGN did not in any way violate the NDPA by supplying the required data to the government of the Gambia. Your Excellencies, Section 41, 42, and 43 of the NDPA appear to be relevant in this matter, Your Excellency. I must also cite before this court Article 2.11 and Article 2.12 of the NDPR 2019. Your Excellencies, the general rule under Section 41 of the NDPA is that cross-border transfer of data is not permissible. It may, however, be done under certain circumstances provided for under this same Section 41 to include where it has been forced. Your Excellencies, thank you very much. That includes where it has first been established, Your Excellencies, that the importing state, which is Gambia in this instance case, has sufficient legal framework to ensure the protection of data that is to be transferred to it. And also in any of the circumstances, any, Your Excellencies, stated in Section 43 of the Act. We might ask the question, how do we then establish that the importing country has the sufficient legal framework or has passed the adequacy test? In this case, we move to Section 42 of the Act, which states that where the importing state has similar legal framework to that which is obtainable in Nigeria, it is considered to have passed the adequacy test, Your Excellencies. Alternatively, even when that test has not been passed, we move on to Section 43, which provides that in any of the cases, not conjunctive but disjunctive, you may proceed to transmit such data. One may be obtaining the consent of the said data subject, or where it is done for national or public security or interest. Your Excellencies, we must first establish for this court that the Gambia has the necessary legal framework to ensure the protection of the data to be transmitted to them, despite not having a comprehensive Data Protection Act. Your Excellencies, as held in the case of Incorporated Trustees of Digital Rights Lawyers versus FRN, the court stated in that case that even though the FRN did not have a comprehensive data protection law, they had numerous regulations and also an authority that dealt with that matter, and that was sufficient until a comprehensive act was enacted. Your Excellencies, I refer this court to Section 23 of the Gambian Constitution, which guarantees the right to privacy. I also refer this court to the Information, Communication and Technology Act of 2019, which creates the Communication Technology Agency of 2019. I submit on this issue to the effect. Your Excellencies, I would like to invite my co-agents to address this court on our substantive issues 4, 5, and 6.
Thank you very much, Your Excellencies. Your Excellencies, on issue 4, it is our contention that Light Touch Incorporation has not failed to fulfill its obligation under the Nigeria Data Protection Act. Firstly, pursuant to the provision of Section 65 of the Nigeria Data Protection Act, it defines a data controller as a person, a private entity, a public commission, or a private agency that determines the purpose and means of processing of a data. Your Excellencies, pursuant to the provision of Section 24, 25, and 26, it also lists the principles which a data controller should follow in the process of processing a data. And it provides for the principle of consent, it provides for the principle of legitimacy, accountability, fairness, and lawfulness. However, the provision of Section 3, subsection C of the Nigeria Data Protection Act provides an exception to this. It provides an exception to the obligation of a data controller. And it states that a data controller, the obligation of a data controller in Section 24, 25, 26 can be waived if such data processing is done by a competent authority. The National Security Agency is a competent authority that does its actions for the favor of national security. Also, in the case of Breyer versus Germany, the court held that a public authority has the power to get information, to collect information without the consent of to collect data without the consent of the data subject and without a court order. Your Excellencies, it is our position, it is our submission that Light Touch Incorporation truly had an obligation, but the obligation was waived based on the permissiveness of the provision of Article 3, Paragraph C of the Nigeria Data Protection Act. This is our submission on this, Your Excellencies. Moving on to the fourth issue, Your Excellencies, it's our contention that Light Touch Incorporation, to the fifth issue, Your Excellencies, it's our.
Can you cite regional law on the citing on the waiver of the right or the protection? So the African Charter, the Data Protection Act.
Like the supplementary act on data
Yeah,
protection.
because if
with-
you cite to me your domestic law as the basis for violating some regional obligation, that's not enough. And that's why I asked your colleague about the status of your domestic law before this court.
Thank you very
Okay?
much, Your Excellencies. The provision of Article 24 of the Supplementary Act on Data Protection within ECOWAS also provides for the exceptions to the principles, and it includes also national security, Your Excellencies. May I proceed, Your Excellencies? Thank you very much, Your Excellencies. On the fifth issue, it is our contention that Light Touch Incorporation was not in error when it's contended that Mr. Cole and several others could not move their data from Legit Socials to another platform. Your Excellencies, we recognize the right of a data subject to his right of data portability, that is moving his data from one platform to another. However, still citing the provision of Section 3, Paragraph C of the Nigeria Data Protection Act and the provision of Article 24 of the Supplementary Act of ECOWAS on data protection, of data protection within ECOWAS, it posits that when the data processing is done by a competent authority for the purpose of national security, then the obligation of that data controller can be waived. Also, Your Excellencies, the provision of Section 25, subsection 1, paragraph B of the Nigeria Data Protection Act provides that, notwithstanding the provisions of the Nigeria Data Protection Act, if the data processing will be considered lawful, if it is done by a competent authority in which the data controller has an obligation to. Your Excellencies, it is our submission on this issue that, okay, all right, the provision of Section 25, subsection 1, paragraph B of the Nigeria Data Protection Act posits that, notwithstanding the provisions of the Nigeria Data Protection Act, it provides that the data processing will be lawful if it is done by a competent authority for the purpose of national security in which the data controller is subject to. Thank you very much, Your Excellencies. Your Excellencies, on this issue, it is our submission that Light Touch Corporation was not in error when it held that Mr. Cole and several others could not move their data from Legit Socials to another platform. Moving on to the last issue, Your Excellencies, it is our contention that the Nigeria Data Protection Commission is independent. Your Excellencies, the provision of Article 14, subsection 1 and subsection 2 of the Supplementary Act of ECOWAS on data protection within ECOWAS, as well as Article 11, subsection 1, paragraph A and B of the African Union Convention on Cybersecurity and Personal Data Protection, as well as Section 7 of the Nigeria Data Protection Act, posits that there must be an independent commission that regulates data protection in Nigeria. Your Excellencies, it's our contention that Nigeria has an independent data protection commission in Nigeria. Also, Your Excellencies, the United Nations Human Rights Commission in 1992 proposed the principles that determines the independence of a commission. And the first is the power over composition and appointment, the second is infrastructure, and the third is mandate. Your Excellencies, going by the provision of Section 9 of the Nigeria Data Protection Act, I'm referring to the Nigeria Data Protection Act because it is the act that established the Nigeria Data Protection. So there might not be a corresponding provision in the other international conventions, since this is very particular to our country. Your Excellencies, the provision of Section 9 posits that the agency has the power of composition and appointment. However, it is done by the president. This is premised on the fact that the agency is stemmed from the executive arm of government. Also on infrastructure, the provision of Section 4, subsection 3, paragraph A and B posits that the infrastructure of the commission is to be located in the Federal Capital Territory. Your Excellencies, on stable mandates for its members. The provision of Section 5, paragraph A to paragraph O posits the mandate of the Nigeria Data Protection Commission. Your Excellencies, it is our contention that the Nigeria Data Protection Commission made its observation and its decisions independently without relying on the directive or on the submission of the National Security Agency. Your Excellencies, we seek the leave of this court to adopt our prayers as filed in our memorials.
Excellencies, as earlier introduced, my name is Aditayo Michael. The respondents have made vexatious allegations before this honorable court. With respect to personal jurisdiction, they have argued that the second, third, and fourth respondents cannot be parties before the court. But this is a misunderstanding of the express provision of Article 9 sub 1 and Article 9 sub 2 of the ECOWAS protocol, which allows this honorable court to apply ECOWAS documents and directives, as well as subsidiary instruments. The Supplementary Act on Data Protection within ECOWAS, which the respondents have admitted is greater than their constitution, Your Excellency, mandates National Data Protection Commission, as well as also places obligations on Light Touch Incorporation and Light Good Consultancy. It's our contention that based on these two provisions of the protocol, this honorable court can exercise personal jurisdiction over the claims brought against them with respect to their obligation under the Supplementary Act, Your Excellency. They also argue, Your Excellency, that fake news, incitement, and hate speech are sufficient reason for, on the basis of national security. Excellencies, these are rebuttals, and we urge this honorable court to find on our behalf. Thank you.
Yes, once again, Your Excellencies, I am A.T. Olagunju. You said you had a question for me. There's also rebuttals. Yes. Yes, Your Excellency. Your Excellencies, just because they had a proper legal basis for doing it. Like I stated, Your Excellencies, Section 41 and 42 of the NDPA prescribes certain requirements for qualifying an importing country that is referred loosely as the adequacy test. Now, a country will be said to have passed that adequacy test under Section 42 of the NDPA if they have in place a similar legal framework to that which is obtainable in Nigeria. Your Excellencies, like I stated earlier, Section 23 of the Gambian Constitution guarantees the right to privacy, Your Excellencies. In addition to this, Gambia also has the Information and Communication Act of 2009. In addition to this, they also have, Your Excellencies, unfortunately, Your Excellencies, Gambia does not have a comprehensive Data Protection Act. However,
So on what basis
yes, Your Excellency.
did they meet the adequacy doctrine?
Your Excellencies, I relied on the case of the Incorporated Trustees of Digital Rights Lawyers Initiative versus FRN, which was a 2021 case instituted before this court, before the Nigerian Data Protection Act came into force in 2023, where the applicants challenged the fulfillment by Nigeria of the requirement to have a comprehensive Data Protection Act. The court, however, held that since Nigeria, although not having a comprehensive act, had a regulation in place, had certain authorities and other provisions in the Constitution.
So can you compare that Gambian regulation,
Yes, Your
right?
Excellency.
Information and Communication Technology
Act of
Act.
2019 to
Can you compare that with the NDPR?
Yes, Your Excellency.
No.
Can I proceed, Your Excellency?
Can you compare that? If you look at that regulation,
Yes, Your
right,
Excellency.
or that act, and is it in pari passu? Do they look similar with the NDPR? Because at the case law you are relying on,
Yes, Your Excellency.
at that time, we
Yes, Your
had
Excellency.
a data protection regulation
Yes, Your Excellency.
explicitly for data protection.
Yes, Your
This
Excellency.
act you are referring to is not for data protection,
Your Excellency, it is not
right?
specifically on data protection.
It is not for data protection.
It is not specifically for data protection.
Okay. Before I go to I'm trying to help you,
Yes, Your
right?
Excellency.
But you seem to be, have you heard about the white list?
No, Your Excellency.
Have you heard about the Malabo Convention?
Yes, Your Excellency.
So tell me about the Malabo Convention.
Your Excellencies, if I may take the hint from what you're trying to, the help you are trying to render, I must also inform this court that Gambia is a signatory to the Supplementary Act on Personal Data Protection within ECOWAS, as well as the Malabo Convention.
Yeah, going, you want to carry me to where I don't know.
Your Excellencies, Your Excellencies.
I said you should tell us about the Malabo Convention.
Your Excellency.
And then you've decided to take the hints beyond where. So the thing is, we're not grading you based on the quality of your arguments. That has already been graded, right? But in building your advocacy and your understanding of the facts, I often say that really there's no bad case. It's your ability to understand the facts and skew the narrative to your advantage. And then for the court to look at the facts, right? And Gambia does not have a data protection law. And there's no how you swing it. So the first thing you've got to look for is what is the closest to an explicit data protection law. So if you say to me as a court that Gambia has ratified the Malabo Convention, is on the white list, right, has expressly taken these regional steps, that qualifies them to meet that adequacy threshold. Then you can now annex this law you're referring to, right? And I'll tell you, look, I can go to the criminal code and bring provisions in the Nigerian criminal code that have to do with data protection and rely on that as a basis for an adequate data protection regime.
Most obliged, Your Excellency.
Okay.
Thank you very much.
Okay, so still on this point.
Yes, Your
So-
Excellency.
I think the first thing to mention is that even based on the ECOWAS Supplementary Act, so you have specifically Article 4 that requires member states to set up a framework for data protection in their respective states.
Yes, Your Excellency.
Now, the case that you had relied upon, the contention then was primary law against secondary law. So there was a contention whether under the Article 4, what are the requirements is for us to have a substantive law on data protection, or whether having a subsidiary law, which is the NDPR, and then you have other framework pursuant to the NDPR, whether that would be adequate. Now, the argument was that if you look at that provision, it doesn't necessarily test for adequacy. It tests for having a framework on data protection. So regardless of whether you have a primary law or you have a secondary law, that will still meet that test. It was on that basis that the court held in that regard. But in your own case, the law that you're urging us to admit or the law that you're urging us to take cognizance of is strictly not on data protection. So even before the NDPR, we had fragmented laws on data protection. So if you look at the NCC Act, you will see provisions on data protection. If you look at the Cybersecurity Act, you will see provisions on data protection and the Constitution as well. But that is still not adequate enough. You need a standalone bespoke provision on data protection. And that was what led us to the regulation. But what you're urging us to admit is not anywhere, exactly, is not anywhere close to what Nigeria had at the time, right? So it's not a comparable situation. Now, the second point is with respect to you saying that the right to privacy is not absolute. That's fine. But even within that provision that you relied upon, it actually prescribes circumstances pursuant to which that right can be derogated from. And one of those circumstances is when the laws of the National Assembly so permits. Now, if you look at the section that I think your colleague erroneously interpreted, right, which is the Data Protection Act, specifically, I think section 2 or thereabouts, it talks about instances where national security may not necessarily permit you to, like in a wholesale, apply the provisions of the Data Protection Act. But there are still specific provisions that have been carved out from that exception. And I think you read it wrongly. So section 24, for instance, which deals with the principles, and 25, they apply to national security, they apply to enforcement agencies. So if you're taking my data, for instance, I have the right to be informed why you're taking my data, regardless of whatever the situation is. So if you don't have an enabling law, so if, for instance, it's the enforcement agency, the police force, they have a law that guides the processing of their data, right? So they can't just, out of their own discretion, decide to stop me and tell me and ask me to provide certain information that may not be consistent with the provisions of their acts, or because they are trying to fight against national security. So these things are circumscribed based on the parameters that we have under that law. But I think you wrongly interpreted that law to mean that you have a blanket exception. No. So certain provisions of the Data Protection Act will still apply to you. The first is the Constitution will apply to you. The second is Section 24 will apply to you. The third is your rights under Section 25 will still apply to national security situations. So that is no absolute. Then I think the other point is with respect to the transfer of data. Now, I think you made so much case about having an adequacy framework. But I think in terms of the indices for that adequacy, you've not been able to demonstrate it fully to the courts because you already relied on having a data protection law. That is not the only index in terms of determining whether you've passed your adequacy requirements. As he rightly said, what I expected you to have started from is the whitelist. Presently, because the Data Protection Commission has the right to designate certain countries as being adequate. Now, before the Data Protection Act, you had the whitelist, and that whitelist has been preserved by virtue of the transitional provision that we have under the Act. So today, is Gambia in that list? That is the starting point. If Gambia is not in that list, can you, based on the indices under the Act, say that Gambia has an adequacy framework? Another index other than having a data protection law is having an accessible court for the enforcement of data protection. So I want to have a situation where we've had decided cases where people have been able to enforce the data protection rights. I want to have a situation where I can go to court and ventilate my actions with respect to data protection. Is that happening in Gambia? You've not been able to educate us on that. The other point is how independent is the regulator over there? That is another index that is supposed to be taken into cognizance. You've not demonstrated that the Gambia authority is absolutely independent, that they are not supposed to be in any way have their discretion fettered in whatever manner. Another index is in terms of security agencies. Do they have access to data over there? Is it the case that once I submit to the Gambia authority, they will have an Interpol somewhere that will then intercept that data and listen to my private conversation? You've not been able to demonstrate that. So sitting right here, I'm not convinced that that Gambia has an adequacy framework in terms of data protection. So these are the things. I know this is just a learning forum, and I'm not trying to think towards any direction, but I think an attempt to look at the law, the index, and try to demonstrate that we've complied with all the requirements of the law would have taken us to a comfortable zone in terms of making a determination on how to take this forward. So thank you very much.
If you had built a case around the whitelist, right? I would have seen you laboring to convince us that they have an adequate, they meet that adequacy threshold. And what that would have told us is that you understand your limitations. See, as a lawyer, especially when you are on this side of the table, you must know how blind your spot is. You must know how bad or good your case is. And so the courts must see you laboring to, I'll give you an analogy. When someone is on a surgical table, you see the doctors battling to get that person back to life, right? It's different from when someone is having a simple scheduled procedure. You get the drift, right? The procedure is scheduled and everything is going and nothing is expected to go wrong. You are trying to fix, and your argument is as if what you have done, right? And done well, but what you've done is that you've tried to build a case. You've tried to create scenarios to fit into your narrative as against working with what you have to achieve a result, right? So take that feedback and build on it.
Thank you very much, Your Excellency.
And then reduce your tone, right? It's good to be forceful. And I said this especially for young lawyers. In the legal profession, the concept of respect is very, very relative. And the concept of, especially in litigation, your confidence may be misconstrued. Unfortunately, we're in a chauvinistic world. I'm not one of them, right? But your boldness and your temerity may be misconstrued by a judge. And that can become a problem, right? And then you must know your courts. They say a good lawyer is one who knows the judge, not one who knows the law. The interpretation of that is not that you are able to influence the judge. Interpretation of that is that you understand the body language of the person you are speaking to, because the court is human. And so if you understand the body language, sometimes our body language may be that you're not saying anything that warrants us paying extra attention, right? But a couple of times you have said things that have piqued our interest. And the moment we get up to listen to you, I saw you just switch to the next point. Our interest in what you're saying may just be your selling point and your ability to convince us. So you dwell a bit more to get us excited before we lose tempo. But when I look up to listen to you and you just jump over, I'm like, okay.
Thank you, sir.
First of all, brooches are not worn on shirts. Should be on your jacket. So if you're wearing a brooch, you should put it on your jacket.
No, you don't have to do it here.
You don't have to do it here. Just giving you that feedback.
Yeah. Maybe we do the generic feedback. Yeah, they're done. So we'll do the generic. Yeah, they've done the rebuttal. So we'll do the generic because I have class, so I have to go. Okay, so just first of all, to congratulate all of you. Really, really great performances, okay? Usually the respondent side always struggles. And I always say it because the respondent side always has a harder case, okay? In these situations, especially when you're dealing with West Africa, you can sit down actually. When you're dealing with West Africa or when you're dealing with Africa, sometimes you look at the case and it's just so blatant. And as a lawyer, you're really struggling to figure out how to use the law to represent and protect your client, okay? But really, for the first time since I've been doing this, you guys really did a great job of, making the respondent case look not as bad as it really was, okay? So really good job on that. And I mean, all of your presentations were good. The feedback, really useful. You should listen to that, read body language, be very clear on the content of your case. And then even if you're being, I mean, this is, you're being argumentative, it's part of the process. Also, as much as possible, try to be as respectful as possible, but be very clear on your point, okay? Now, you did very well. Just continue to push your point. and make the claim, okay? Don't allow anybody, you're making a case and you're saying this is the situation and we're saying, well, maybe it doesn't look like. So find very intelligent and respectful ways to do that. And I think you all kind of tried on that today. Now, with regard to the international law aspect of this, it was very interesting to see you all rely very heavily on the Constitution, on the Data Protection Act, on data protection regulations or whatever. And you can actually cite those before a regional or an international court, but they have, I mean, they're basically, municipal law is a statement of fact before an international court, okay? It has no binding authority. So if you're going to use it to do something, you use it to prove a case based on whatever international law or international instrument you are relying on. So always make your first port of call the regional instrument so if it's the African Charter, or if it's the Supplementary Act, let that be the first thing that you say. So like my colleague was saying, you say, oh, this act allows us to rely on national security or to do so and so. Now, if you look at our Constitution, this is a national security situation. So you're basically using it to prove the thing that you've done in accordance with the international law, the regional provision, okay? So those are my points, and I'll let my colleagues give their own feedback.
Okay. Okay, so my views align. They actually align with hers in terms of the respondent side, trying to sustain some of the arguments that they've canvassed to compare. They have like a compelling argument why we think that indeed they should have a good defense in terms of responding to the case that has been submitted for adjudication before the courts. But specifically on the appellant side, I think you have a good case. Your case was really spot on. However, I didn't really see that push in terms of my expectation, based on the arguments that was indeed demonstrated before the court. Maybe I will start with your rebutter. So from the rebutter, I think you didn't really address some of the issues that they raised. So specifically, they raised issues around the applicability of Data Protection Act based on national security. And I expected you to have commented on that. That wasn't said, right? There was no comment regarding that. Also, they raised issues around whether the second and the third respondents, whether they can be argued or arguably whether they can be construed as controllers in the sense of what we have under the Data Protection Act. Now, what I expected you to have demonstrated is the scope of the Data Protection Act in terms of those that it applies to, right? In terms of the application provision. So if you look at that act, it clearly has extraterritorial effects to the extent that you're processing data of someone that is resident in Nigeria. So it doesn't matter where you are resident. To the extent that you're processing data of someone that is resident in Nigeria, whether it's a foreigner that is resident in Nigeria or a citizen of Nigeria, automatically you're banned by the data protection laws. The only time that it won't apply to you is where the data subject is also offshore, right? So if you're offshore and you're processing the data of a Nigerian citizen that is also offshore, it clearly doesn't apply to you. So that would have been a rebuttal to the argument on the points on whether Data Protection Act applies to them, right? Then the other rebuttal that you also did not demonstrate is with respect to the jurisdiction points that they raised. So they had argued that the only person that can be indeed brought forward before this court is only the federal government. So the National Data Protection Commission, the third and the fourth respondents, they have no business being in this court. And I didn't get any rebuttal to that. Did you?
That was my rebuttal. I argued that the supplementary act and like
No, but assuming jurisdiction is different from assuming jurisdiction on the persons that are before the courts. So it's not so much as to whether the subject matter is actually one in respect of which the court can assume jurisdiction. It's not in doubt. But the question is, can you bring the second, third, and fourth respondents before the courts? Right? So that's the question. Or is it more appropriate to limit your claims to just the federal government? I would have expected you to demonstrate agency construct as it relates to the second respondents, right? Because the second respondent is clearly an agency of the federal government. And I would have expected you to explain cases around the agency construct in terms of decided cases that have demonstrated that, the actions of the agencies as well is as good as the actions of the principal. So if I can sue the agents, the question is, do I still need to sue the, if I can sue the principal, the question is, can I still sue the agents, right? On the third and the fourth respondents, I really did not get any rebuttal from you, other than the fact that you're talking about subject matter jurisdiction. I really did not get any rebuttal from that.
Madam Chief Justice, she wants to leave, and the photographer said they should have a group photograph with two judges before you leave. Just a quick one. No, you stay there. They will come down. Olga, just so you continue with because I'm really enjoying your very, very big grammars. All right. Amor, she's fantastic. Thank you very much. Sorry for that break in transmission.
Okay, so on the legality, proportionality, and necessity points, I also think that was not fully addressed, and I will tell you why. So if you look at the facts that has been presented before us, you will notice that there is an objective in terms of what the federal government seeks to achieve with the directive. And that objective is harmonization of all the databases of the MDA. It has nothing to do with mining information from social media. Social media is not an MDA, right? So the expectation, because I needed you to tie this back to domestic law, because if you look at section 24, it talks about the obligation of the data controller to indeed process data that is relevant and also process data that is adequate and indeed not excessive, right? So the question is, when you tie it to the proportionality and the necessity points, the question then is, the mining of information from social media, is it really necessary by reference to the objective of that directive? It is not necessary, in my view, right? So I needed you to demonstrate that, but that wasn't done. So even in terms of the proportionality, so the proportionality is a balancing test. You have to look at the information that has been collected against the objective of what the federal government is trying to achieve. So if the whole objective is to harmonize databases of the MDAs and then have a single identifier being your NIM for identification purposes, how would information from social media advance that cause? So I didn't see any demonstration of that, right? Because you just talked about, and that was why I needed you to explain, but even with your explanation, it wasn't evident in terms of what you're trying to achieve. So I needed that explanation from you regarding those three tests that you mentioned. Then so I just hope I've addressed everything. Okay, so the other point is that you had actually mentioned in course of your argument that there's a violation of section 14, but your response was blanket. I wasn't able to get any indication of the specific wordings of that provision that you're relating to or that you're trying to advance your cause on by reference to tying it back to the specific scenario that we are considering. Now, I I would have expected that you look at the whole ambit of section 24 and then point me to specifically, because it's not the entirety of section 24 that is relevant for this course, right? I needed you to have point me specifically to the provisions that have been violated. And I will give you a good example that never even occurred in the whole of this. That is the doctrine of accuracy. So if you're getting information from social media, how accurate is the information on social media? Someone can put up an information on Celestina that Celestina is a man. And it will just be there. If you do Google, you will see it. So how accurate is that information? So the reliability of information that you get on social media is also doubtful. And if you look at the principle, something that ordinarily should guide your processing activity is reliability, accuracy. So I needed you to point me specifically to those provisions and relate it back to what we are trying to achieve in terms of why you think that they violated those provisions, but that never came out, right? Another thing is with respect to the transfer of information to other agencies. I don't think anybody commented on that. Maybe I didn't hear properly. I think I only heard transfer to other countries, but in terms of other governmental agency. Oh, sorry? No, other agency. It transfer. Yeah, because it's part of the fact, if I'm not mistaken. But nobody addressed it. No, but even though it's not an issue, it still has to do with transfer, right? It still goes to whether they violated the provisions, because there's a blanket issue that deals with whether they've complied with the provisions of the Act. So even though it's not a pointed issue, but it still goes to compliance. So nobody addressed me on that. And I think for me, that was really germane, because that has to do with interagency transfer. Can you just make a blanket transfer, or are you still required to apply the provisions of data protection in that instance? Then I think another thing with respect to pseudonymization, I don't know who spoke on that. I'm not sure. But the response that I expected with respect to pseudonymization, so rather than demonstrating that is a technical measure, I didn't get the link, or I didn't get any response categorically saying that the fact that your data has been pseudonymized doesn't mean that you don't have to comply with the provisions of Data Protection Act. Did you comment on that? Exactly, but you still limited it to cross-border transfer. So cross-border transfer deals with the legal basis. It doesn't deal with the principle. So that means even when you're dealing with cross-border transfer, you still need to apply Section 24, right? So if you look at the principles, you have to look at it from the perspective of the general principle, the principle that also deals with sensitive data, the principle that deals with data consigning kits, and then cross-border transfer in terms of the legal principles. But what is indeed unifying all of this is the principles, rather. So what is unifying all of this is the principle. So I needed you to have demonstrated to me why you think that even though the data has been pseudonymized, that it doesn't in any way take it away from the ambit of the regime of the Data Protection Act. So that didn't really come out clear. Yeah, I think generally.
Thank you. The guru has spoken, so I'll just, if you go to appellate courts, when the lead judgment is read, then the others will just say, I've had the privilege of reading my learned brother's judgment, and I concur. So everything she said, and it's good that you take the feedback. For Mike, I said you must know the judge, right? But you must also learn not to get distracted by the judge. And many times we were distracting you. You were, because you wanted us to validate what you were saying. Validation does not come from the bench. It comes from the quality of your arguments. So whether I'm listening to you, whether I'm not listening to you, I may not like your face. And judgment is not reached during oral advocacy. Oral advocacy only gets the judge to probably remember a couple of things. It is when we sit back and read your submissions that where your oral advocacy will come in would be at some point say, oh, and I think he also said this. It may bring to remembrance. So don't take when I'm looking down or to think that you're not making sense. You get distracted and you get derailed, and that's. But I listen to both of you, and what does section 24(1) say? Tell me. It used 3 keywords. What are those words? I'm asking all of you, the 4 of you now. So, but whoever answers. Did any of you harp on the transparency aspect? Because everything is hinged on it. Everything is hinged on it. And your argument didn't hit that nail on the head. Transparent. It says you must deal in a fair, lawful, and transparent. What is the definition of transparent? This is what I'm drinking. I can see clearly through it. If you bring a bottle of water in a black bottle and give me to drink, 2 things will happen. I'll probably ask you, where did you get the water from? Right? I'll want you to convince me that it's good, right? But even more importantly, I wouldn't be too certain that it's good, even when I taste it. But if you bring a bottle of water, the first thing I see is the clarity of it. And then I'll know whether I want to taste it or not, right? And this entire case is hinged heavily on transparency. The phrase strategic uses, what does it mean? None of you attacked it. You were looking at the agency and you failed to look at the facts that have led to that. Does the phrase strategic uses meet the transparency threshold? Because it's your argument, right? And if I were the respondent, I would say, look, you have not said in any way where we have not met, where the actions contravene section 24. You understand me, right? So always look at, so when keywords are used, those words are used intentionally to drive you to a particular point. And so you must ask myself, why was this phrase strategic uses used in this case? Is there something they want me to see? Is there something we're trying to establish, right? And then you juxtapose it with the law, right? The part of the act that talks about it. So take that feedback and work on it. And then always build on, not on, while you're trying to remedy your case or you're trying to make a bad case look good, right? But always know that one leg of the tripod that holds your defense is hinged heavily on the arguments of the party that think they are doing it right. Look for their blind spots. You didn't look for their blind spots. Look for their blind spot and hit them hard. Like a colleague said, you have a bad case, right? But you've been able to have an argument that has winged it reasonably well. But you did that doing so much work and not even building on the weakness of some of the things that they missed, right? So take that. And then you see this, your reliance on English case law. There are indigenous cases. You've just not done your research. This over-reliance on keep giving me UK, Sweden, that's good, right? But there's indigenous case law. You've heard about the word autochthony, right? When you say something is autochthonous, laws are bespoke. And oftentimes, what you pick from a foreign law may be good and great, right? But to a very large extent, an indigenous law, what it does is that it factors in the peculiarities of our own case. Now, if you are dealing with laws, data protection laws in Africa, and data protection laws in Europe. There's a lot of difference, especially with independence of government, especially with corruption, especially with military rule, right? So what obtains in the United Kingdom is not what will necessarily obtain in Africa. And so you must strive to do a bit more research to find out what is happening, even if there are high court decisions, right? Because most of the data protection case law we have are within the high court, but they are very interesting arguments. Very, very interesting. In fact, then it was the NDPR, but it was trying to balance the provisions of the Constitution with provisions of the NDPR and trying to stretch the NDPR into having a balance from the privacy rights as enshrined in the Constitution. Such arguments would enrich the conversation. But when you keep giving me foreign laws, because they are easy to find. If you go to the Federal High Court and ask for fundamental rights judgments, right? You will, if you do that in if you do that in Lagos, I'm sure you will find some fundamental rights actions that have been decided in line of data protection and data privacy enforcement, right? Today we have the NDPA in place and people are already in court. Even the arguments before, but even preliminary rulings will help enrich the conversation. As lawyers, you must strive to build internal capacity. Reliance on foreign case law will not give you that edge that shows an out-of-the-box approach, right? Because it's easy to get. I can, on the comfort of my computer, just be churning them out. But when you get up and go to the libraries, go to the courts, and then you find some of these case laws and the arguments that have been espoused by the parties as well as the judge, it will enrich the conversation and bring. And then last thing that you must know is that always start, when you're talking about regional courts, right? Always start with the laws that are applicable to them. I don't want to start hearing constitution. And that's why I asked you that question, right? I don't want to start hearing even the NDPA that seems to be the fulcrum of this argument, right? It's really not it's really not what we want to hear in a regional court. What is the law that gives you protection from us? Identify that, build strongly on that, and annex it to whatever indigenous laws you are relying on. Show me a clear annexation of these laws. And don't come to me and be telling me about NDPA, telling me about constitution, for all you care, I may not give a hoot. But if you come to me and say, the law that establishes my court, the treaties upon which we now sit to adjudicate upon, have established, someone cited the Sudan case, even though that was a very, it was ingenious, but it was a very risky case to cite because it's really not tied. It's more from human rights crimes, right? But good, at least you use it to establish exhaustion of local remedies. But if you also took your time to read the case, right, you will find that the court established the fact that what it is concerned about are the laws upon which it stands and not the indigenous laws of the parties. And both of you have fallen very well into that. Again, that's a blind spot that you could have worked on, right? And other than that, you guys are winners. For you to get to this stage, you're winners. You just need to hone your skills, build on it, and continue to improve where you are. But you have something going for you. Thank you.
Wow. Thank you very much. I mean, you can see obvious display of expertise in their explanation, in their illustrations, in the comments and the feedback that I've given you. Help me to kindly give them a very robust round of applause. Thank you very much, Celestina Nwabuse, Edefe, thank you in absentia. Also, Mr. Morui, we are most grateful, sir. Okay, so we have come to the meat of the meat pie, like I usually say. We have come to the bus stop, Gongon, where we want to disembark. She has compiled them. So I'm not going to be doing that work. I'll let them do the announcement of the results. And like they said, everybody's a winner, having come this far. You guys have been very, very impressive. So I'll hand over the mic now to our Madam Chief Justice. She will announce the results. But I want you to know, like I told you in the morning, I never say never. It's never over until it is over. That one team won and the other lost is not the end of the road for that team yet until we are done this afternoon. All right, Celestina.
Okay, thank you, sir. Okay, so I was going to leave this session and perhaps just say we don't have a winner because because the both teams, you did excellently well. You did excellently well. Unfortunately, I've been mandated to pronounce on the scores and to rate one over the other. And that's why I'm doing this. But ordinarily, trust me, you did excellently well. And I think, as my colleague said, this is the first time also on my own side where I will be attending a competition of this nature, and the respondent side pulled together like a compelling argument. I was indeed impressed with the kind of arguments that you put forward. So please, can you give a round of applause to yourself? So based on the scores that I have with me, on a scale of 100, for the respondents, we have an overall score of 73.6. Please, can you put the hands for them? And on the part of the applicants, we have an overall score of 78.3.
Another round of applause, please. Thank you very much, our judges. Team 16 has won this match, but like I said, that really doesn't say too much until after the conclusion of the second proceedings. Anyway, that is how it stands. Applicants 78.3, respondent 73.6. So that will be the end of proceedings for this particular session. There's lunch, but the girl is on her way. She'll be here very shortly. Especially our attendees, you should wait behind though, because we promised you, and we always fulfill our promises. Thank you very much. She's asking for the schools. We are not going to tell you the schools. At least not yet. Yeah, you are conscious of, okay, I'll tell you in camera. I'll tell you in camera. Very well, very well. All right, so that will be it. We'll have a break of 30 minutes. We'll reconvene by 2 for the second session. But in the meantime, I hope the lady will be here. We'll serve lunch and then we'll reconvene. Thank you very much. Okay. Don't go, come. Picture. Group picture. Meeting body here. Oh yeah.
LMS, come to smoke cannabis. Doctor say make a pop one of this. Make me fly like say I'm Aladdin. Come bring some kind melodies. Oh, mama, myself no do pass like this. So many things inside of my jeans. I slide down the beatings.
I talk one, they go and swallow me, yeah. Share one good, share one bad, share one real, share one fair. Me, I not do again. Oh, you see wins that they want shallow, we say. They want to bully me, or more, I don't do calm. Talk my shit right up in your face, me, I know this shit. I don't do too much peace and you right now. I go put you on D&D. Keep your eyes shut on me because it get a sick move around me where you fit in the body and D. I don't work out with the security because I shot in one shakabula inside my GLE. Oh, show, I'm be Baba, it's your be my confidence, no rely on any number one. Too many soloists when I go, they call me Solomon. You say she gone because it's a busy, I be done. I'ma make a no too tall, make a so free sit down. Because if I talk one, they go and swallow me, yeah. Share one good, share one bad, share one real, share one fair. Me, I don't do it again. Oh, you see wins that they want shallow, we say. They want to bully me, or more, I don't do calm. Talk my shit right up in your face, me, I know this shit. I don't do too much peace and you right now. I go put you on D&D. Keep your eyes shut on them because it get a sick move around me where you fit in the body and D. I don't work out with the security because I shot in one shakabula inside my GLE. Oh, show, I'm the evil neck, but they go let D&D. I don't do too much peace and you right now. I go put you on D&D. Keep your eyes shut on them because it get a sick move around me where you fit in the body and D. I don't work out with the security because I shot in one shakabula inside my GLE. Oh, show, I'm the evil neck, but they go let D&D.
Holy Ghost fire, supernatural, boost my confidence. My cocaine, my heart desire, give me happiness. I know the target, cause you give me ginger for the time minutes. You're my true lover, my mommy water. Give me happiness.
Oh yeah, the pantas, 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 the pantas.
Holy Ghost fire, supernatural, boost my confidence. My cocaine, my heart desire, give me happiness. I know the target, cause you give me ginger for the time minutes. You're my true lover, my mommy water, give me happiness.
10,000 days off on my neck, stop drinking, babe. Tequila don't they hit me for liver. It's like the indica, it is sativa. Anytime that I smoke, this girl's been looking like wife materials. Is it this or that? If I seek, I find how I feel inside. I will let you know I am super high. I can feel my eyes. They say love is blind, but I can't see you. Oh yeah, the pantas, 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 the pantas.
Holy Ghost fire, supernatural, boost my confidence. My cocaine, my heart desire, give me happiness. I know the target, 'cause you give me ginger all the time. Only. You're my true lover, my mommy water, give me happiness.
You give me life, beat is solar. Can't feel your love taking over. On a good day, I be loner. See what you make me discover. Girl, you don't change my persona. The revelation is in order. All the pressure I've been under. Why I call you Ngozi? God don't bless me Ngozi. No deserve is kind loving. The loving way you show me. Private lounging on Paris. With expensive room service. No one make me do like this. Girl, I got you, no worries, no worries. He did do me wow, wow. Scatter my intana. Craving on sala. No killing me kitana. Check all of his wow. My protection is the lala. Every no disala. No killing me kitana. He did do me wow, wow, wow. Scatter my intana. Craving on sala. No killing me kitana. Check all of his wow. My protection is the lala. Every no disala. No killing me kitana.
I know you're waiting around hastily to you. In my Panamera, hola, hola, ho. I'm levitating, I feel like ecstasy when you whisper na kupenda. The thing you put for this, your dollar. Got my heart and my soul on love. And I wanna go crazy with you. Through the night till the sun come on. Let's do it all for love. There's nothing for any corporal. I never wanna lose this. To you I belong. This must be love.
He did do me wow, wow. Scatter my intana. Craving on sala. No killing me kitana. Check all of his wow. My protection is the lala. Every no disala. No killing me kitana. He did do me wow, wow, wow. Scatter my intana. Craving on sala. No killing me kitana. Check all of his wow. My protection is the lala. Every no disala. No killing me kitana. Everything you do me, I like. My best friend, the love of my life. I know if day without. I be you won't make it bad. It's someone to hold on to. Girl, you know fear I did for you. I go on the matter for me and you. Make I be the reason you be living through love. Why I call you Ngozi? God don't bless me Ngozi. No deserve is kind loving. The loving way you show me. Private lounging on Paris. With expensive room service. No one make me do like this. Girl, I got you, no worries, no worries. He did do me wow, wow. Scatter my intana. Craving on sala. No killing me kitana. Check all of his wow. My protection is the lala. Every no disala. No killing me kitana.
How long will it take you to realize? I don't know who to run to right now. I'm is opening every fire. I'm a safe, bouncy out there. What are we doing, my dear, my dear? I surrender you myself. My hands are in the air. Only time will tell the difference clear. What is the reason you do not have your own peace of mind? Are you having fun or are you doing this thing to survive? pictures of every memories of your life. What's the reason why we're still out here? Chickily can give me one better thing or two. Make a nigga suit and tie, let him fly like you. Turn you to root, you try and tie my shoes. It is that you. What are we doing, my dear, my dear? I surrender you myself. My hands are in the air. Only time will tell the difference. What is the reason you do not have your own peace of mind? Are you having fun or are you doing this thing to survive? Are you taking the pictures of every memories of your life? What's the reason why we're still out here?
One things to want, one more, only car to want. Kashakujo, banana. Alhamdulillah, oh me for dada. Yeah. I'm a girl, walk on. I don't walk in those. Much power sporty, but you zero shorty. Put him one, I'm on two. Only call a mura kiriwa. They give him the twerk your body, twerk your body, twerk. Hollywood, down, twerk the body, twerk the body, twerk your body, twerk. I do it. Oh yeah, hello. Madam, you are hot, so feeling hot, summer helicopter. Hello, Papa mi fago, Papa mi shayo, 247 Oh baby, sọ̀rọ̀ fún mi, sọ̀rọ̀ pa. Lẹ́rọ náà lẹ́rọ fi ṣe fàájì o. Sáré bá ní 1 million kan sí pàdé. Twerk your body, twerk your body, twerk your body, Hollywood, twerk your body, twerk your body, I do it. Twerk your body.
It's Do You December on Showmax, which means enjoying the festive your way with some of your favorites like Wura, Agu, School Run, and Fast X, just to name a few. Do You December is all about you, only on Showmax. Subscribe now at Showmax.
Black for life, black forever. It's got to be my dog. Got such records to get me with the block. Native. All I know is that when I dey coca hit and go. All I know is that when I been shoot I hit oh. All I know is that when I dey coca hit and go. All they know is that when I been shoot I hit oh. So why they wanna cause more? Put him in the cross. Talk, color be their own. Blood, did it on their own. So why they wanna bring blood down to my front door? I don't wanna drink more blood on the dance floor. Supposing I falling with my color like this and that. I'm dressed in black, up Opportunity no be waiting, I go they look them pass. So I light my pass, light that man with my bumpy. Tear got a knot on the monkey. Shake and yash for my money. Odumodu follow the cipher country. I go fill my glass, cup, higher cash, phone, while I the phone. Sean, high ups on the lost. Cause all I know is that when I be cock, I hit and go. All I know is that when I be shoot, I hit the hole. All I know is that when I be cock, I hit and go. All they know is that when I be shoot, I hit the hole. So I don't wanna cause more, put him in the cross. Color me their own, Lord, give it on their own. So I don't wanna bring blood down to my front. No, I don't wanna drink more blood on the dance floor.
I dey always expect these things. Normally. You dey try us, you dey try me. Normally. We came here to party, nah, but you came here to find me. You came here to find me. The thing within my mind.
I go fill my glass, cup, higher cash, phone, while I the phone. Sean, high ups on the lost. Cause
run for your life, they gon' come for your life. And my one true advice, bring a gun to the fight. Let it go. Kiss the kids and the wife over here, shit get real. If for real could be bad when it go. I ain't about to guard like a motherfucker hoe. You bring it to my door, I'ma send you to the road. The thing about war, you won't never know. Closure, the windows closed, they be in the back door. And I don't trust nothing but this God-given flow. You violate of alarm when you pass on dough. They crash out for me, cause I ride for my folks. Take a chance if you want, we gon' dance.
All I know is that when I be cock, I hit and go. All I know is that when I be shoot, I hit their own. All I know is that when I be cock, I hit and go. All they know is that when I be shoot, I hit their own. So I don't wanna cause more, put him in the cross. Color be their own, Lord, give it on their own. So I don't wanna bring blood down to my front. I don't wanna drink more blood on the dance floor.
Supposing I go do my color like this and that. I'm dressed in black. Opportunity no be wasted, I go dey put them pass. So I light my pass, light that man with my pump. Take a run up for the shake and yash. Do the breakfast, baby.
Remember back then, for Barika, me and my chica, they chill with the Sakpa. And Bukata, for the matter. Eruku, gone for the Zanga. Now the music, now you give me liberty. Call it freedom, I dey fuck. I do pay do mare, I do pay for all over. Now you give me the package, so make nobody come de buga. When I do titi kati, they dancing, they josi you. Oh no, oh no, oh no, oh no, oh no. Bami Korio, Bami Kyolo, Murakasa Mikos, Aje Onkolos, Mocello, Cello, Moticello, Cello. Story, oh. Hello. Been on the bench, I've been waiting for Oluwa to come activate me. I'm my boy, London, biggie man. I wish you mommy can see me now. Fine lady, oh, me now. They won't call me Moot to me now. I do baby, do my now you give me the package. Nobody come de buga. When I do tikati, they dance on Josie, oh. Jello, jello.
It's Do You December on Showmax, which means enjoying the festive your way with some of your favorites like Wura, Agu, School Run, and Fast X, just to name a few.
Do You December is all about you. Only on Showmax. Subscribe now at Showmax.
I got my issues, I admit that. You got some things that hold you back. But we are acting like we're children, looking to blame for what we lack. Before we lose everything we have tomorrow, can we forget what went wrong yesterday?
I'm in the streets, thinking I could be discreet, but I messed up something sweet. Just what I needed, some time to tell you, please. I'm on my knees, this was never meant to be. I did rubbish, I did it just what it is. But I just full of knees, my lungs they barely breathe. You're what I need, I admit it, I admit. No one could ever love me better than you did. No one could ever love me better than you did. I could have thought these feelings would cease, but then I miss you laying in my sheets. Sure you don't see as my heart did I bleed. I don't wanna lose you to what I did. And for your heart, that place the highest bid. Give me an offer, I just can't resist. And for pidgin and English, I did speak. You know I ain't speaking Japanese.
I got my issues, I admit that. You got some things that hold you back. But we are acting like we're children, looking to blame for what we lack. Before we lose everything we have tomorrow, can we forget what went wrong yesterday, darling?
It's my fault and I blame me, I don't blame the alcohol. I really should have known better, wasn't thinking at all. Maybe with my penis, but not with my brain, and I know this was off the limits, now I gotta watch as you go. It's the apology I couldn't say to you, I know. If I could take back what I did, I would do it for sure. If I could get you the word, I would do it for you. It's loyalty you deserve, I'ma give it to you. I could have thought these feelings would cease, but then I miss you laying in my sheets. Sure you don't see as my heart did I bleed. I don't wanna lose you to what I did. And for your heart, that place the highest bid. Give me an offer, I just can't resist. And for pidgin and English, I did speak. You know I ain't speaking Japanese.
I got my issues, I admit that. You got some things that hold you back. But we are acting like we're children, looking to blame for what we lack. Before we lose everything we have tomorrow, can we forget what went wrong yesterday? that's up on my neck. Stop drinking, babe. Tequila don't they hit me for liver. It's like the indica, it is sativa. Anytime that I smoke, this girl's been looking like wife materials. Is it this or that? If I sick, I find how I feel inside. I will let you know I am super high. I can feel my eyes. They say love is blind, but I can't see you. Oh, yeah, the fantasy, the fantasy. You give me dinner for the diamond. You're my true lover, my mommy water. Give me happiness.
It's Due You December on Showmax, which means enjoying the festive your way with some of your favorites like Wura, Agu, School Run, and Fast X, just to name a few.
Do You December is all about you. Only on Showmax. Subscribe now at Showmax.
Make me sweat, make me harder, make me lose my breath, make me water, make me sweat, make me harder, make me lose my breath, make me water.
Normally, I could keep my cool, but tonight I'm whining. I'ma be in a dangerous mood. Can you match my timing? Telling me that you're really about it, what you're hiding. Talk is cheap, so show me that you understand. I like it. Can you blow my mind? Set off my whole body. If I give you my time, can you snatch my soul from me? I don't wanna wait. Come take me where I ain't been before. Can you blow my mind? Set off my whole body, whole body.
Make me sweat, make me harder, make me lose my breath, make me water, make me
against the federal government of Nigeria, the Nigerian Data Protection Commission, Light Touch Incorporation, Light Gold Consultancy Africa. Application number ECW CCJ APP 2023/01.
Your co-counsel.
Thank you very much, Your
Perhaps
Excellencies.
before we go on, we should introduce ourselves so that you know who the panel is or who
Most
the
obliged,
people
Your
on the
Excellencies.
panel. Okay, so I am Dr. Bumia Finowi. I'll let my colleagues introduce themselves.
Okay. My name is Eustace Arrow.
I'm Philip Folarin.
Thank you. So appearances, please.
Your Excellencies, before we take our humble appearance before this honorable court, appearing for Team 22, and in compliance with Rule 4 sub-10 of the official rules guiding this competition, in the absence of the agent for the applicant, we shall proceed, subject to the kind discretion of the court, to present our case ex parte before this honorable court. Most grateful, Your Excellencies. Madam President, Your Excellencies, I am Olabosi Inioluwa, and with me is my learned colleague and co-agent, Oluduro Samuel. And together, we humbly announce our appearance as agents for the respondents in this case. Your Excellencies, the case before this honorable court is between Mr. Jones Cole, together with the Incorporated Trustees for Digital Justice for Africans, hereafter referred to as the first and second applicant respectively, against the federal government of Nigeria, the Nigerian Data Protection Commission, Light Touch Incorporation, and Light Gold Consultancy Africa, hereafter referred to as the first, second, and fourth respondents respectively.
Just a minute, Mr. Olaposi, we are trying to confirm the time you have.
Very much grateful, Your Excellencies. Your Excellencies, appearing as the lead agent, I shall be arguing canvassing argument for 20 minutes. Thereafter, my co-agent, Oluduro Samuel, shall be canvassing argument for subsequent issues for subsequent 10 minutes, making a total of 30 minutes before this honorable court.
Okay, please proceed. Yes.
Most grateful, Your Excellencies. Your Excellencies, I haven't mentioned the names of the parties of the case to this case. We shall proceed to inform the court about the facts of the case, subject to the decision of the court. Your Excellencies, I would like to ask, would Your Excellencies like to benefit from the summary of facts of this case? Most grateful, Your Excellencies, upon the inauguration of the federal government of Nigeria, of the new government in the Federal Republic of Nigeria, the federal government, through the office of the National Security Advisor, embarked on the collection of data for the provision of more security architecture in the country. Your Excellencies, this was perpetrated through the use of an artificial intelligence tool known as Capture IT. Capture IT collected the data of citizens from relevant sources, such as Legit Socials. Legit Socials is a trendy social media platform owned by the third respondent and managed by the fourth respondent. The first applicant in this case, Mr. Jones Cole, has approached the NDPC, the Nigerian Data Protection Commission, and second respondent in this case in his complaint against the actions of the federal government. However, this complaint has been dismissed as lacking in merit. He has therefore approached this court and concurrently the Federal High Court of Nigeria to seek redress. Your Excellencies, flowing from the fact of this case, 6 pivotal issues, aside from the preliminary issues of jurisdiction, admissibility, and local standing, have been extrapolated for determination. We humbly point the direction of the court to page 8 of our brief of argument containing these substantive issues. Your Excellencies, also going by the provision of Article 32 sub 1 of the ECOWAS Community Court Rules of Procedure of 2002, our brief of argument has been duly filed before this court, whereby seek the leave of this court to adopt our brief of argument. Most graceful Your Excellencies, moving on to the preliminary issues for determination, which I shall canvass together with substantive issue 1, 2, and 3 for 20 minutes. And as I rightly earlier said, my learned friend and co-counsel, Oludro Samuel, shall canvass argument on merit of issue 4, 5, and 6 for subsequent 10 minutes. Your Excellencies, going to the preliminary issues for determination on issues relating to jurisdiction, admissibility, and local standing. It is the submission, humble submission of the respondents, that this court lacks jurisdiction to hear the case at hand. Your Excellencies, the jurisdiction of the ECOWAS Community Court has been rightly spelled out, particularly as it relates to violations of human rights in the Supplementary Protocol of 2005, Article 9, Sub 4. Article 9 sub 4 of the Supplementary Protocol provides that this court shall have jurisdiction to determine cases of human rights violations that happen in member states. Your Excellencies, while we submit that Nigeria indeed, according to paragraph 2 of the compromise, is a member of the ECOWAS community. However, what is indeed the fulcrum of the jurisdiction of this court, that is, the violation of human rights, cannot be identified in this case. It is our humble submission that there has been no violation of human rights at all in the case at hand. Owing to Article 2 of the Supplementary Act for Personal Data Protection within the ECOWAS, that of 2010, it provides that each member state shall establish a legal framework for protection of privacy of data without prejudice to general interest. Your Excellency, I repeat, without prejudice to general interest. Combining this with Article 37 sub 2 of the African Charter on Human and People's Rights, which provides that in granting rights to citizens, we shall put forward consideration on collective rights. Your Excellencies, I repeat, collective rights or collective security. Given these provisions, together with the provisions of Section 25 sub 1B4 of the Nigerian Data Protection Act, which leaves the exception of public interest in the processing of data, we humbly submit before this court that the government of Nigeria, in this instant case, has worked along the lines of the law, fully provided by both international and local statutes in the collection of data, and has not violated any, and therefore there is no human rights violation with which this court may have jurisdiction. Your Excellencies, moving on to the issue of admissibility, it has well been provided in Article 10 sub D of the 2005 Supplementary Protocol, which gives two fundamental requirements for admissibility before this court. One, that the case is brought by a non-anonymous person. And two, that this case has not been instituted again before another international court. Your Excellencies, while we submit that the first requirement has been satisfied, as this case has been brought pursuant to paragraph 16 of the compromise by Mr. Jones Co. and not by an anonymous person. However, the second requirement has not been fully satisfied, as this case has been instituted before another court, although the Federal High Court is not a court of international jurisdiction. However, its decisions can militate against the settlement of this instant case, as has been rightly provided in Article 22, sub 2 of the ECOWAS community of the ECOWAS protocol establishing this honorable court, providing that when there is a dispute before the ECOWAS community courts, the parties to the dispute shall not engage in actions that can militate against the settlement of the dispute. Your Excellencies, we humbly submit that Mr. Jones Co, in this case, being a party to this case, as in instituting this same matter before another court, is taking an action that can militate against a settlement. This line of thought has been given judicial credence in a plethora of cases, even in the local case of Sheriff versus PDP, where the court held that it amounts to nothing but an abuse of court process for an applicant to institute the same matter before two different courts. And we humbly submit for this case to be inadmissible for that very purpose, Your Excellencies, abuse of court process. Moving on to the plenary issue of local standing. The requirement of local standing before the ECOWAS Community Court has been well spelled out in the case of Reverend Solomon MFA and 11 others versus Federal Republic of Nigeria. Citation duly contained on page 13, paragraph 13 of our brief of argument. The court in that case gave 3 fundamental requirements for local standing. That 1, there is indeed a violation of human rights. That 2, that the applicant is a victim of the violation and has suffered personal loss. And thirdly, that the respondent is responsible for the violation. Your Excellencies, it is our humble submission that none of this requirement has been satisfied in this case. As we have earlier argued, there is no trace of any human rights violation at all in the case at hand. The applicant is not a victim at all, and Your Excellencies, going by the Latin maxim, ex nihilo nihil fit, nothing comes from nothing. The respondent in this case cannot be responsible for a violation of a right that does not exist in the first place. Having provided before this honorable court statutory as well as paragraphs of the compromise, we humbly submit entirely on the preliminary issues that this court lacks jurisdiction to hear this case, that the case is inadmissible before the court for abuse of court process, and that Mr. Jones Co lacks local standing to bring this case before this court. And if this court shall so rule, we humbly beg this court at this juncture to strike out this case. In fact, dismiss it and throw it in the bin of judicial precedence. However, if this court shall rule otherwise, we shall proceed to identify and canvass arguments on our substantive issues. Thank you very much, Your Excellencies. I shall now proceed to our substantive issues for determination. To issue 1, on whether or not the federal government of Nigeria, through the Office of the National Security Advisor, has proper legal basis for the collation and aggregation of Mr. Co, and as well as several other data. Your Excellencies, we make first and foremost reference to the provision of Article 24 of the Supplementary Act of 2010, establishing the Equals Community Court, which provides that there shall be a principle of legality. It provides explicitly that in the processing of data shall be done in a fair, legal, and non-transparent way. This has further been given judicial credence in the local law of Nigeria, Section 21, sub 1A, of the Nigerian Data Protection Act, hereafter to be referred to as the NDPA, provides explicitly that data shall be processed in a fair and credible manner. Your Excellencies, moving on to paragraph 3 of the compromise, it states clearly the purposes for which the data in this case was being processed. It states that the government of Nigeria, the federal government, the first respondent in this case, was processing the data for security and law enforcement purposes. Your Excellencies, this purpose has been clearly stated, satisfying the principle of legality, fairness, and transparency under both international and local statutes. Your Excellencies, moving on also to the provision of the law in Section 25, sub 1B4 of the Nigerian Data Protection Act. It states that the processing of data shall be lawful. I repeat, Your Excellencies, shall be lawful when it is done in the performance of a task that is carried out in public interest, in the exercise of official authority. As earlier stated, the federal government in this case was carrying out public interest and doing so by an official authority. The official authority known as the National Security Advisor, ably provided for in Section 25 sub G of the 3rd schedule to the Constitution of the Federal Republic of Nigeria, which provides that the National Security Advisor shall be an inherent part of the National Security Council. This makes the National Security Advisor, hereafter to refer to as the NSA, an official authority. Your Excellencies, we wish to bring the court to the notice of the fact of Section 14 sub 2B of the Constitution as well, which provides that the security and welfare of the people shall be the primary purpose of government. This being so, combined with Article 27 sub 2 of the African Human and People's Rights that provides for collective security, as has been represented in a plethora of cases, including the case of Okedara versus Attorney General, citation duly contained on page 16, paragraph 29 of our brief of arguments. We thus humbly submit that the federal government in this instance is has proper legal basis, as it has fulfilled the basis for collection of data both in local and international statutes. Your Excellencies, moving on to the second issue for determination on whether or not the federal government of Nigeria, through the office of the NSA, violated the NDPA in failing to comply with due process in the deployment of Capture IT, due process relating to fairness, opacity or transparency, accountability, and algorithmic bias. And second, whether or not Mr. Cole's and several other people's copyrights were violated in his development and training. The respondent humbly submits in the negative. It is our vehement contention that the federal government of Nigeria has not violated any provision of the NDPA in the deployment of Capture IT relating to fairness, accountability, transparency, or algorithm bias. Your Excellencies, starting with fairness, as has been provided for in Article 32 of the Supplementary Act of 2010, Your Excellencies, and also transparency, as has also been provided for in Article 27 of the same law. These international statutes have been localized in Section 24(1)(a) of the Nigerian Data Protection Act, which states that data shall be processed in a fair and transparent manner. Your Excellencies, we make reference to paragraph 9 as well as paragraph 10 of the compromise, which states clearly that the federal government in this case, through the office of the National Security Advisor, was making media briefings. I repeat, media briefings, Your Excellencies, for sake of emphasis, that the government was making the public aware of its activities of collecting their data, fulfilling the requirements for transparency and accountability, as it has been provided in Article 24 sub 1A and Article 24 sub 3 of the NDPA. Your Excellencies, on the issue of algorithmic bias, it is our vehement contention, going by paragraph 12 of the compromise, that the issue of the bias against the Kembari people is not one of algorithmic issue, but one of their historical facts. The plague that has affected the Kembari people is their threat of secession, which is in their historical part, and that is why they have been labeled and are being watched by security agencies. Your Excellencies, as we have earlier stated, the security and welfare of the people is the primary purpose of the government. Therefore, the algorithmic bias, being said, is not a function of a deployment issue with due process related to Capture IT, but rather a consequence of, humbly so, the historical fact of the people. Moving on to the second part of this issue, Your Excellencies, as to whether or not the copyright of Mr. Jones Cole, as well as several others, were violated in the development and training of Capture IT. The respondent again submits otherwise. It is our vehement contention that their copyright was not in any way violated. Your Excellencies, copyright has been defined by Section 2 of the Copyright Act of 2022 to be inherent in literary and artistic authors, or in authors of literary and artistic work. Your Excellencies, Section 9, Section 10, Section 11, 12, and 13 of the Copyright Act of 2022 goes further to outlist the rights that is available to authors. However, exceptions have been granted under the same act. We make reference to Section 20 of the Copyright Act that provides for certain exceptions, and particularly Section 20 sub 1F provides that when a work is being used by the government under the control or the influence of the government, it shall not amount to copyright infringement if the use is in public interest. Your Excellencies, if the use is in public interest, it goes ahead to provide two exceptions under the same exception. That first, there must be no revenue derived therefrom, and second, it must not substantially affect the market value of the work. It's our humble submission that these two requirements has been fulfilled in this case. The government is not making any money or profit from the data of the people, and it does not substantially affect it as to affect its market value. We humbly submit their copyright has not been violated in any way, and we holistically submit on this second issue that there is no fault in due process in the deployment of Capture IT, and that the copyright of citizens were not violated. Moving on to the third and final issues on my part for determination as to whether or not the government complied with the NDPA in supplying the requirement, in supplying the information, the requested information to the government of the Gambia. We answer in the affirmative. It is our vehement contention that the government comply with every ounce of due process. Your Excellencies, transborder transfer is enshrined in Article 19 sub 1 of the Supplementary Act on Personal Data Protection of 2010. It is also established in Section 1 of the NDPA, Section 41(1), apologies, Your Excellencies, which provides explicitly that in cross-border transfer, the recipient of such data shall be a country subject to a law. It is our humble submission before this honorable court that the Republic of the Gambia is indeed a state subject to a law, as it is a signatory to the 2010 ECOWAS Supplementary Act on personal data protection. Not only this, but recently in 2019, it has, through its Public Utilities Regulatory Authority, provided for a draft data protection and privacy policy strategy. Your Excellencies, given these laws, drafts, and policies made by the Republic of Gambia, we humbly submit that the Republic of Gambia fulfills the requirements in Section 41(1) of the NDPA. And as to the mode of the transfer of this data, the mode of transfer of data for security purposes has been defined by Section 42 of the NDPA, as well as Section 39. Section 39 provides for that measures shall be taken in the protection of data, including pseudonymization. Your Excellencies, paragraph 11 of the compromise identifies that the federal government of Nigeria, in transferring the data to the Republic of the Gambia, indeed pseudonymized the data. Owing to this protection and this provision under local laws having been fulfilled by the federal government in the transfer of this data, we humbly submit before this honorable court that the government is not in breach of any violations regarding the NDPA as well as other relevant law in the transfer of data to the Republic of the Gambia. If I shall be of no further questioning or clarification before this honorable court, I shall now defer proceedings to my learned colleague and co-agent, Oluduro Samuel, to canvass arguments on issue 4, 5, and 6. It has been an honor arguing before this court.
Mr. Olaposi.
Olaposi. Yes, Your Excellency.
Yes. Okay, so I have a couple of questions for you. And just to get a sense of so under your first issue, that's you claim that the federal government has the legal basis for collecting and aggregating Mr. Cole's personal data.
Your Excellency, it is our claim that the federal government in this case, the first respondent, has a clear basis as provided by paragraph 3 of the compromise.
Okay. So I'm just curious why you've relied only on the Act and the African Charter in your argument, because well, let me hear from you. Why have you relied only on? Because I assume that the body of laws is a bit wider than that in Nigeria.
Thank you very much for that question, Your Excellencies. In argument for the legal basis of which the federal government has collated the right of the citizens, we make our first ounce of argument from Article 2 of the ECOWAS protocol, Your Excellencies, the Article 2 of the ECOWAS protocol of 2010, the Supplementary Act of 2010, and also in combining that, we combine it with Article 27(2) of the African Charter on Human and People's Rights, and also relevant provisions in the NDPA, like the provision in Section 25 sub 1B4, Your Excellency.
So, since the enactment of the NDPA, the previous, let me put my question this way. Since the enactment of the NDPA, the previous body of laws that regulated data protection in Nigeria, what happened to them?
Your Excellency, thank you very much for that question. The previous body of laws that regulated data protection in Nigeria included the Nigerian Data Protection Regulation, as well as the Nigerian Data Protection Framework. Your Excellency, we recognize these policies and these laws. However, given the principle, before Your Excellencies, given the principle of covering the field, we hold need to say that relevant provisions have been provided for in the Nigerian Data Protection Act, and provisions of Nigerian Protection Regulation cannot be inconsistent. If inconsistent, it is not and void.
Okay. just final question on this issue. So aside from the NDPR, that's the Nigerian Data Protection Regulation, and the implementation framework, we also have the guidelines for management of public institution, the guidelines for personal data, management of personal data by public institution. So this came into effect in 2020, when NITDA was still the primary agent of data protection. And based on the saving provision of the Act, the guidelines is still in force. The guidelines still works. All right. So what the guideline seeks to do is to provide specific instructions to public institutions on how they handle personal data. Do you understand? So you then see why I flowed my question from why did you rely on only because this is a guideline that was directed specifically to public institutions. Do you understand? Well, I take your point that the NDPA is a holistic act and touches on everything. So I take your point on that.
Thank you very much, Your Excellency.
Just I'm also curious on why he had also cited the draft data protection strategy, since it's still just a draft.
Your Excellency, that is for the Republic of the Gambia.
Yes.
In our argument for the Republic of Gambia, we make mention of the fact that they are a state subject to a law, owing to the fact that they are a signatory to the Supplementary Act, the ECOWAS Supplementary Act of 2010 on personal data protection. And we put this as an additional point that, in fact, in 2019, they have gone ahead to begin to put measures in place, including that draft, Your Excellency.
Okay. Would you say that what was transferred to Gambia constitutes personal data?
Your
In
Excellency,
light of the security measures the federal government, your clients took to protect would you say they still constitute personal data?
thank you very much for that question, Your Excellencies. The security measure the federal government has taken in this instant case, in the transfer of that data, is known as pseudonymization. To start with, personal data has been defined in both Article 1 and Article 1 of the ECOWAS Supplementary Act of 2010, as well as Section 65, the Interpretation Act of the NDPA. However, Your Excellencies, pseudonymization has also been defined in the same Section 65 of the NDPA as a means of inscription which when used, the recipient of such data cannot determine who the data is about without additional information. Your Excellencies, going by this definition, we humbly submit before this court that this data, although cannot be defined without additional information, still constitute personal data, given the fact that personal data is any data relating to an individual as defined by Section 65 of the NDPA.
Okay. Last question for you. Would you say the data that your client collected constitutes sensitive personal data?
Your Excellencies, if I may,
based on the facts.
Thank you very much for that question, Your Excellencies. Sensitive personal data has also been given its definition within the context of the NDPA, the Nigerian Data Protection Act, Your Excellencies. Section 65 of the Nigerian Data Protection Act defines sensitive personal data to mean personal data relating to an individual's genetic and biometric data, race or ethnic origin, religion or similar beliefs, as well as other things like health status, self-life, political opinion. Your Excellencies, going by paragraph 11 of the compromise, the Republic of Gambia asks for data concerning certain political activities. Definitely, this data transferred to them involved their political opinions, satisfying the provision of sensitive personal data under Section 65 of the NDPA.
So would you say your clients complied in all the requirements for sensitive, since you've agreed now that it's sensitive personal data, would you say your client complied with the requirements for sensitive personal data?
Thank you very much for that question, Your Excellencies. The requirement for transfer of data beyond the borders of a country like earlier cited before, Your Excellencies, have been well provided for under Section 42. It says in Section 42 that given this requirement, there is adequate protection. Your Excellencies, adequate protection. And Section 42 provides that these measures are not different from the measures contained in Section 39. Your Excellencies, Section 39 sub 2B provides that one of these measures that can be taken by a data controller or data processor is pseudonymization. And that is what our client has employed, skillfully employed, in the transfer of data to the Gambia.
Olakposi.
Your Excellency.
Olakposi Niolu, am I correct?
Very right, Your Excellency.
I can see that you are forceful with your points, which is very good. You are presenting ex parte. The applicants are not around. But that is not to say that the general principle of law should not be observed, that you base your case based on the strength of your case, not on the weakness or the absence of the other party's case. I don't know whether but I tried to listen to you very well. You have made some good points and, you are forceful and convincing with your points. But again, did you consider Section 45 of the 1999 Constitution, the derogation provisions?
The derogation provisions from human rights, Your Excellencies.
Section 45 of the 1999 Constitution, as amended.
Section 45, Your Excellencies, humbly submitting that Section 45 has not been captured in our line of argument.
Okay, no problem. That's what I just wanted to. Then, in the course of your submission, you said that your client, or let me put it this way, that Kambari people, they have a history, the history of scission, and that it's not that they were being victimized or stigmatized. But if a particular people have a history of scission or whatever, should it be an excuse for your clients to make them a target? Because I was trying to look at your submission in that regard, that they have a history, but should that be a justification for, okay, now there should be a special target for terror-related, whatever?
Thank you very much for that clear question, Your Excellencies. The issue relating to the